Edwin Walker. I want you to, man, Edwin, tell us what in the world is in this U.S. Congress anti-gun bill and when does it go into effect? Edwin, welcome to come and talk it, sir.
Yeah, Mike. Thanks for having me. It's always great to be on your show here. So the bill, the thing about it is that I know that obviously Cornyn was looked at as a traitor, and the 10 Republicans were looked at as traitors, and Cornyn was booed at the Republican convention. But the bill itself, once you delve down into it, it spends a lot of money and it requests a lot of commissions and a lot of studies. And, Cornyn, I've seen him do his press conferences. He's like, look, we are not affecting the ability of people to get firearms, and we're not affecting the firearms that can be received. And, technically he's true. It really doesn't do that. And certainly if you compare it to that atrocity that came out of the House of Representatives, House Resolution 7910, that is the type of bill that we always need to stay vigilant of, because that does do the things that basically the top three things that we need to always be aware of as gun owners. We need to be aware of any kind of proposed quote unquote assault weapons ban. We need to be aware of any kind of quote unquote high capacity magazine ban, and we need to be aware of anything that impairs the right of people to make a private intrastate transfer of firearms to one individual to another. Those are really the top three things that really I fret about the Congress making rules about. Fortunately, this compromise bill goes nowhere near doing any of that, and I don't think it provides an avenue for the anti-gun folks to do it later on just by simply amending this. So what it does do is, like I said, it spends a whole bunch of money. It commissions a whole bunch of studies. It tells where states and local governments and school districts can get money and how they can spend it, things like that. But what it does with regard to guns specifically is that it does not impose a ban on 18, 19, 20-year-olds having their ability to purchase a rifle. What it does do is it now says that certain juvenile records can be reviewed, and it does kind of create a de facto waiting period for these juveniles. And so juveniles won't be able to go rush in and buy a rifle. There will be a 3-day waiting period, and then that can be expanded up to 10 business days, which in reality is actually 14 real days, because business days don't include the weekends. And so, and if there's any kind of already disqualifying characteristic that comes up in the search of the juvenile record, so it doesn't create a new disqualification with the juvenile records. It says that if the juvenile records turn up something that is already disqualifying under 18 U.S.C. 922, then they're disqualified. So that means that if they've been adjudicated as committing a felony, or they've been involuntarily committed to a mental facility, something like that. So it doesn't really create a new disqualification. It just simply expands the ability to ferret out whether or not a disqualification already exists. Now, this is where I see the possibility of them expanding that in the future. So I think it is highly likely that after a few years, they will say, look, isn't this fantastic? This works so well for 18, 19, 20-year-olds. We need to expand it to everybody, that their juvenile records are accessible. And I believe it's only juvenile records after they have become 16. I think that's the way that I read it. But so that is a possibility for expansion to everyone. But like I said, it doesn't really create a new disqualification. It just kind of opens up a new category of records that can be looked at for an existing disqualification. So that's what it does with regard to the 21-year-olds, which is, like I said, as opposed to the bill that came out of the House, which wanted a hard prohibition, no 18, 19, 20-year-olds can buy a rifle, period. And so that is obviously in the nature of compromise. The next thing that it does.
Before you go to the next one, I want to make sure I'm clear on this one. So this means that if you're 18, 19, or 20 years old, there's a possibility you may get delayed up to 10 business days.
That is correct.
Okay, and then
And which,
they also get a chance to look into your criminal history.
well, your juvenile
Your
history.
juvenile. Okay, got it. Juvenile history.
Yes.
Okay.
So to see if, as a juvenile, you were ever adjudicated for a crime that would have been considered a felony if an adult had done it, or if you had been committed to a mental health facility as a juvenile. And so, what's interesting about that is that this particular procedure requirement is supposed to exist for the next 10 years, and within this 10-year period, the government is supposed to begin integrating those records into the regular NICS background check. So after 10 years, it will go back to being just a regular NICS background check, but it will include all of these juvenile records. So the delay period is only going to exist for 10 years, and then the law assumes that after 10 years, the records will be fully integrated, and it goes back to being an instant background check, so there will be no waiting period. You'll either get your deny or proceed fairly immediately.
Okay, and that's from the ages of 18 to 20.
19, yeah, 18, 19, 20. However, like I said, with that caveat that I absolutely can see the Democrats coming back and saying, this worked out fantastic. Let's just apply it to everyone.
Got it.
So I do believe that is one of the Trojan horses that is built into the bill that will eventually impact everybody who does have one of these records.
Okay.
Like I said, if you're an adult now and you don't have one of these records, then you've got nothing to worry about. Like I said, there's no new prohibition that's being created that you would have to worry about.
Okay.
So now, in the realm of prohibited persons, this bill also closes what everybody has been calling the boyfriend loophole. And believe me, I hate that term. I hate the way that anytime whenever you talk about gun laws, they throw in the word loophole, because just, as we know, as a general principle, every single gun law that exists has been a compromise on behalf of the gun owner. So if you want to just, get in your time machine and go back to 1933, any adult could go into a hardware store and purchase a fully automatic Thompson, 1921A rifle and have no interference from the federal government whatsoever. So everything from that time period, every federal law from that time period forward has been a compromise to chip away at that ability that we had in 1933. So every single federal gun law is a compromise. And as, we like to say around the office, yesterday's compromise becomes today's loophole. And so that's why I hate the word loophole, is that there was a reason that that dating violence, boyfriend, not being able to access dating relations, not considering assaults that occur while people are dating is not family violence. There's a reason that was not included way back whenever the family violence provision was made. And that's because it's extremely difficult to define what that is. And so, since then, the anti-gun folks have been saying, oh, my God, they allow domestic abusers to have guns. So this presumably addresses that.
Okay.
So what that says is that if an individual has been convicted of a misdemeanor crime of assault, so keep in mind, I want everybody to remember, if you're convicted of a felony, you're totally prohibited already. So it doesn't matter what crime it is. If it's a felony, you're a prohibited person. So this specifically only addresses misdemeanor crimes. So if you're convicted of a misdemeanor crime of violence, it could be an assault, maybe a terroristic threat. It's just defined as a crime of violence. You're convicted of a misdemeanor, and it turns out that the complainant or the victim in that crime meets the definition of you being in a dating relationship with them, then you're a prohibited person. You become a prohibited person.
And this is for life?
No.
Okay.
That's the interesting part.
All right, hold that thought, Edwin. I'm gonna let you finish that on the other side of the break here. We come back, we're talking about the new gun legislation that's going to go into effect. Edwin's going to tell us when this is going to go into effect, and he's breaking it down for us right now. This is Michael Cargill, and you are listening to Come and Talk It.